Well, hello, everybody. Welcome to our YouTube Live. I hope you can hear me and see me. We are talking today about whether or not you can install cameras on your rental property, and we're happy to take any of your questions. I've got a set of questions here that I have collected from our lists and from our Facebook group. If you are not a member of either our list or our Facebook group, we certainly welcome you to join either one of those. Go to facebook.com if you have rental property in the state of Texas. If that's the case, then you can join us there and ask questions, not just of us, but also of other landlords who are routinely on the site, helping each other out, making sure that we share our experiences and help build each other up. So that's one good reason. But also, you get to ask these questions ahead of time. I'll take a look at them and I'll present them here live for everyone to enjoy. For those of you who are new, if you didn't get a chance to submit your questions ahead of time, that's okay. We are going to give you an opportunity to submit those questions through the stream. I see that a number of you are on. I see that James has said hello. Francisca Miranda, waving hi. Hi, Ernie. It's Vandale Gentry. How are you? Looks good seeing everybody who is here. I'm happy to welcome everybody to the live stream so we can get started on whether or not you can install cameras on your rental property. Well, the first thing to consider when you're thinking about installing cameras on your rental property is what is it that your lease already says about this. And so generally speaking, landlords don't preempt this right by saying, I'm definitely not going to do it. And so your lease might be absolutely silent on the matter. And so if you're kind of wishy-washy on it and your lease allows it, well, that's great. If your lease excludes it, well, that's bad. You definitely can't. But if your lease is silent on it, generally speaking, in most jurisdictions, there is no problem, generally speaking, installing security cameras. But the second consideration is, does your jurisdiction say something different? And if your jurisdiction does, if you're in a state or in a city that limits the use of cameras on rental property, well, you're going to want to know that that's the case. It doesn't happen to be the case in the state of Texas. And so you are allowed to have security cameras on your rental property outside of the rental property. Certainly, if you have a single camera inside the property, that's going to cause a problem, and your tenant is likely going to have the right to exclude that particular camera. So if you've got that, you're probably going to want to remove it, and certainly you don't want to install something like that. I see Sandra Espinosa says hi, and Olga Bocharieva says hi. Good to see you as well. Glad that all of you have joined, and we want to keep going with the topic. So what does your lease say about it? What does the law say about it? And where are you generally allowed to put cameras? These go on the outside. Now, what's likely going to happen is you're going to get some pushback from your tenant. And so you can mention to the tenant that these things are both an asset for them and for you, and it helps secure the property, but that essentially you are allowed to alter the premises as long as you don't harm the tenant. And technically, this is not a harm that comes to the tenant. Now, they may say, oh, well, my privacy is being invaded. Well, the truth is, we don't have a reasonable expectation of privacy outside of the home. And certainly the tenant doesn't have a reasonable expectation of privacy in any part of the premises that isn't inside behind a closed door. And so anything that's outside is generally available to the public. And if it's behind a fence, you're the only person who really can't be excluded. I mean, unless, of course, your lease specifically precludes you from accessing the premises, you should have every right to put a camera on the perimeter of your property. So the other thing to consider is whether you give access to the tenant. And I know that in a lot of cases where we have like a Ring doorbell camera, sometimes landlords like to give access to that to the tenant. And while that might be a good idea in terms of shared access, I would certainly never relinquish full access. You don't want to give them password privileges, for example, because that actually puts you and future tenants at risk. So certainly don't ever do that. You're going to want to make sure that you are maintaining full control of the password. And so if you've got the idea that you want to put up cameras and you want to share that with your client, your tenant, make sure that you have the ability to share it without giving over the actual control. So in that situation, it could actually be a benefit to the tenant because they have some sense of security as well, and not just feel like they're being watched. They can see what you can see, and they have access to it so that they themselves can keep themselves protected. Now, what happens if you've got cameras and the tenant disables them or in some way blocks them? What can you do? Well, your lease should have a provision in it that allows you to declare this a default, right? So the tenant shouldn't be allowed to alter or change any part of the premises, including a security camera. And so if it turns out that a tenant, blocks access or in some way denies you access to the premises, well, you certainly want to be able to address that issue so that you're not losing the benefit of your cameras. But you want to submit a notice to your tenant declaring that default. And by notifying them of the default, letting them know, look, the lease allows me to do this. The lease does not allow you to alter the premises in some way. Any future occurrence of the same might result in an eviction. Please refrain from touching or altering the cameras or the ability of the cameras to record footage in the future. Now, for those of you who are interested, on Friday, the 29th of August, I am going to be hosting a live event in the Houston area, specifically in Pearland. If you are interested in attending that event, I'm going to show you how to draft and deliver the kinds of notices that we send. Now, certainly it's not going to be on attorney letterhead, but you're going to be able to use these templates on your own letterhead. I'm going to walk you through the process. If you are interested, there is information in the video description below. I welcome you to check that out. Along the bottom of the screen, you should see some information about that if you are interested in showing up to a live event where I will be there. We'll workshop what a good notice of default, notice of non-renewal or termination, and a notice to vacate look like. What do they look like in the state of Texas? How should they be delivered? And what strategies can I offer to you? So this is a paid event that you are all invited to attend, but you're also all going to walk away with drafted notices that I will help you construct that you can use over and over and over again in your practice. So I welcome you, for those of you interested in checking that out, to join us. And so, yes, Olga was asking about that link. For those of you who are on our Facebook group, you would have seen it there. For those of you who are not, you have an opportunity in the description below. Check it out. There's a link there. Feel free to take a look at that. I'm also very interested in you, getting an opportunity to check that out. So let's see. So the last thing to think about whenever you have cameras on your property, understand that cameras don't always make the best evidence in a case. but they can lend some credibility to a statement that you've made. I tend to have landlords all the time come in and say, oh, I've got them on camera. I got the whole conversation on camera. And while it's true that there is footage of people talking, it is unclear just by looking at it who exactly is in the frame. And while it's true that maybe you can hear a conversation, it is unclear what party is saying what because the footage isn't that great or the audio is not that clear. So while yes, it can be helpful, don't be convinced that audio or video is going to be your best evidence in some case. Certainly if you're having to evict a tenant, and if you're doing it for non-rent issues, if you catch, some, violation on camera, again, that could be useful. But sometimes just the fact that your tenant knows that you have cameras up likely prevents things like unauthorized occupants or unauthorized pets or vandalism to the property because they understand that they will easily be caught. And so just the presence of cameras could by themselves prevent lease violations, but don't be convinced that the footage on a camera or the recording of a camera is going to be rock solid evidence. It's better than nothing, but it's not always the best evidence. So, take what you can from this with a grain of salt. I'm hoping that you are able to, benefit from the opportunity of having cameras, because certainly it's better than not. But if, you don't, have something set up right now, I certainly encourage you to do it if you can, because it can be quite a benefit to you, again, in terms of, just keeping an eye, especially if you're a remote landlord. So I hope this was helpful to you. I'm now going to get into the questions. For those of you who have not been able to set up a question yet, I welcome you to add that into the chat below. If you've got a question that you weren't able to send ahead of time, if you add it to the chat below, I will include it in my responses today. I've got a handful of those today. For those of you who are here to hear those responses, I'm happy to help you out with those at this time. So anybody else who would like to add theirs to this, you are welcome to do it later as we progress. So let's see, we've got Born Supreme. I'm in Los Angeles, California. Was wondering what type of attorney I need to hire to help me customize my lease, as well as to consult with regarding tenant landlord matters. We actually do have not a partnership exactly, but I've got a buddy in California who I know practices landlord-tenant law. And if you would like, I will add kianlaw.com into the chat. You can check out his website, and hopefully that's helpful to you because he is a wealth of information out in California. Again, I'm only licensed in the state of Texas, so I wouldn't be able to help you with California law, but he can. And so go ahead and check out his page and follow up with him regarding anything having to do with the laws out in California. So let's see where things stand. Is he in Los Angeles? I can't remember if he's in LA or in San Diego. I think he's in LA, but as I understand it, he covers stuff all over Southern California. So it's worth giving him a call or shooting him an email. But he's the only attorney that I know in California who does the kind of law we do in Texas. So I hope that helps. So right now we have Mark Longoria, who is asking, I have 3 properties. They are each rented by the room. The only expectation of privacy is in the individual bedrooms and bathrooms. The general living area, living room, kitchen, dining room, laundry room, etc., are shared by all tenants. We call that common area or common space. I have security cameras mounted out front and in the backyard. I also have a camera mounted in the kitchen facing the front door in the living room. that could be problematic. I also have signs posted saying that the property is under video surveillance 24/7. One tenant says he feels I'm invading his privacy by having the indoor camera in the kitchen. Can I write a notice to all tenants to sign acknowledging their security camera recording and they release us from the invasion of privacy claims? So here's the thing. I'm not sure why you need a camera from the inside facing the front door. And why that can't be accomplished in some other way. If you're hoping to protect the entrance, my guess is you would get the same sort of protection from a doorbell camera. So what the question is, how do you justify keeping a camera on the inside of the dwelling? And so if you can't justify that, I don't know that the court's going to allow you to keep that camera on the inside. If it gets to a court. Might you be infringing on their privacy? Yes, because while they may not have privacy rights against each other necessarily in the common area, they do have a certain degree of privacy from people outside of the home. And so if all of them, for example, were very comfortable walking around nude, but not comfortable having people outside of the home see them walking around nude, you would be preventing them from doing that because you've got a bird's eye view of all of that. And I think that, again, that's not what's at issue, but that would be an invasion of privacy because they wouldn't be able to do what is normally allowed in one's own home because of that camera. So could they sign and agree? Yes, absolutely they could. But if one of them doesn't, and if they haven't signed that agreement already, I don't know how enforceable it would be. So in the future, could you get them to agree? Yes, I have this camera, it's set there. The other question is, does it record audio? Because they do have some expectation of privacy in what they say, except if they're outside, because then the whole world can hear it. But if it's inside the home, there are certain rights that are more protected, and I don't know that a court would allow you to record audio of what is inside the home. So a couple of things to consider. Could they waive those rights? Yes. If they haven't done it already, you can't just force them to do it. And so if they were really unaware that the camera was there or what exactly it was what it was recording, they might have a rightful claim to ask you to take it down. Again, my suggestion would be replace it with a Ring doorbell camera, and you might get just as good a security. Let's see, Paulo Laura. Can I use cameras for criminal trespassers as evidence with police? Again, potentially. It's going to come down, like I mentioned in the talk before, it's going to come down to the quality of that recording. What can you prove? The fact that I had an incident like this with another client before, and he knew who was in the video. But if I just looked at the video itself, I couldn't tell you who was in it because it was dark. And while I could hear the individual's voice, he could claim, I don't know who that was. Could have been anybody. And he's right, because the video didn't show where the person came from or where they went. It just showed them out in front of the property yelling obscenities. Now, if you listen to the voice, you could make some claim that it was him. And remember, there's a difference in civil court and criminal court. In a criminal court, for criminal trespass, you have a much higher burden. In the civil court, you just have to prove more likely than not. And so you might be able to get away with it in civil court, but again, that's just a might. Probably wouldn't be able to get away with grainy footage or an improper capture. That evidence might get kicked out and become unusable. So it's really going to depend on what is captured in the recording as to how usable it actually is. Let's see, Born to Dream. Okay, great to know. I took a screenshot of his website. I really appreciate it. You're welcome. We got another hello. James says, hi, Ernie. Did you see my earlier question? Oh, I see it now. Actually, I missed two questions. Will you have a workshop, hopefully in the future, for new landlords or those considering to be landlords? We do workshops all the time. This is the Dark Ancient Raven. We do workshops all the time, mostly in the Houston area. So if you are in the Houston area and have you have a access to Houston, or you're around Houston a lot, then yes, you can probably catch us at one of our events. If you are not in the Houston area, well, it gets a little complicated. I post a ton of content here on this channel, so it's possible that you will catch me here on the channel at some live event, and so I welcome you to do that. But if you're not on our mailing list, if you look on the ticker down below, you have you should get access to us through email, or you can give us a call and ask to be put on our mailing list. That's going to help. And so hopefully, if you are not there yet, you can get on our mailing list. Our info is info@attorneyeg.com. Check that out, and hopefully you're able to join those lists and see us at some future event. Again, we've got a number of events planned in the future, and I hope you're able to make at least one of them. James writes, if a physically disabled person is moving in, do they need to request accommodations before the landlord makes any? That's going to depend on what the accommodation is. And so, James, you're asking about an accommodation. What the law requires is that you respond to a reasonable accommodation. And so there is a difference. If the accommodation, for example, here's an easy one. Your home doesn't have a ramp and somebody's in a wheelchair, and they ask that you install a ramp onto the property. Well, that's not a reasonable accommodation unless they are willing to pay to install it and to remove it. If they're willing to do that, then yes, it is reasonable for them to request that. And yeah, the court says, look, if they say, I'd like to install it and I'll pay to install it and remove it, and you deny them just because you don't want it to happen, you're going to have to show, really good reason why that's not a reasonable request. But if they ask you for something, like they ask you to install an elevator because it would be helpful, I don't know how reasonable that would be. You're not the government, and so the government has to do stuff like that. But just a regular homeowner would not be required to do something that is otherwise unreasonable. If they cover the cost for that elevator, maybe, but that would require a really extreme modification to your house, which again would likely render it unreasonable. So on that basis, probably not. So it's going to depend on how reasonable or unreasonable that request is. The disability alone does not give them carte blanche to make every kind of request. Okay. Olga saying, I'm not able to click the video in the video description link. I'm not sure why that's the case. I'll take a look at that. If you have questions about making it to the workshop, send us an email. I'll write our email in the chat. Send us an email, and we'll be happy to send it directly to you. I hope that helps. Let's see. James says, thanks. Spencer Wilson writes, when a tenant moves out, do I need to send a security deposit expense sheet showing all the expenses deducted for the deposit, even if both parties understand there was no refund amount due? Yes. It's always a good idea to send an itemized list of security deposit deductions. In Texas, you are presumed to be returning that deposit no matter what both parties understand to be the case. That's not what matters, because I'll tell you, even though you had a very pleasant conversation at the end, sometimes people's minds change and then they hit you with a demand letter because you never sent that notice, even though they are 100% aware of the condition they left the premises in. You might be holding a $1,500 deposit and they know they did over $2,000 worth of damage to the property. But hey, if if you didn't actually send that notice properly, you may not be entitled to keep that refund in a just a plain reading of the law. So the law says send the notice. I always recommend. Now, in Texas, what it requires is that they fully vacate and that they give you a forwarding address. And then you've got 30 days to return any deposit balance or an itemized list showing how there is no balance, or something in the middle, an itemized list showing how the three scenarios are: you refund the entire deposit, you refund a partial deposit with an itemized list showing what was deducted, or you return none of the deposit and you submit an itemized list of all of the lawful deductions that exceed or meet the exact amount of your security deposit. So I recommend that landlords do this no matter what the situation is, no matter what is understood. You just want to cover your bases and not give a tenant an opportunity to come back and claim that you never had that conversation and that certainly you violated the black letter of the law by not sending the notice as required by law. So whether you have an understanding or not is not what matters. Follow the law every single time just to make sure you are on the right side of the law. So let's move on. Okay, well, let's go to the next question. Christina Bernal says, I have a question about an eviction judgment. If we requested possession only in court from the judge and no money, can the resident still appeal that? Yes, a tenant can always appeal. The things that you're requesting from them are not necessarily what matter. It comes down more to the fact that every single eviction in the state of Texas can be appealed. Residential, commercial, rent, non-rent, doesn't matter. Every single eviction can be appealed at least one time. And so if you think it's going to make things better by not including a request for rent, I guarantee you it doesn't. And here's why, particularly in the state of Texas, why I tell landlords to never take this position. You know, sometimes landlords have this presupposition that by waiving the rent, I'm going to speed up the process. Not true. It takes just as long, whether you've got a rent claim or no rent claim, whether it's a lease violation or a combination of non-payment of rent and lease violations. It doesn't affect the length of the trial. There's also this misconception that by waiving the rent claim, like you mentioned, the tenant has fewer rights. That's just not true. In fact, you kind of open the door and make an appeal easier for them by not including rent. And here's why. In the state of Texas, if a tenant fails to pay rent and you sue to collect that unpaid rent, in order for them to successfully appeal and stay on the property, they have to pay rent into the court's registry at the beginning of that appeal and each month as the appeal continues. This is why it is vitally important to keep your non-payment of rent claim active so that they don't just appeal for free. If you don't make a rent claim, the court essentially understands that you're waiving rent and not interested in rent. So guess what they get to do? They get to appeal for free. They pay nothing, and you have to wait just as long for that eviction appeal. Whereas if they're required to pay rent, and they do, you're entitled to recover those sums from the county after you successfully win your eviction on appeal. However, if they don't pay it in the state of Texas, you have a mechanism for getting them out early. Their appeal can move forward, but they cannot stay on the premises because they failed to pay. If you follow those rules, you're likely going to recover property faster and limit your losses because you're recovering rent from the tenant in a much more effective way. So that's my recommendation in that situation. Laura Prado, is there a 3-day notice to vacate for a squatter in Texas? Yes, it's the exact same notice. You would presume that it would be different in each situation. So, for example, you have a post-foreclosure notice to vacate, or you have a squatter notice to vacate, or you have a holdover notice to vacate, or you have a non-payment of rent notice to vacate, or you have a lease violation notice to vacate. And none of that's true. It's the exact same notice to vacate. Some of the wording might be a little different, but essentially what your notice to vacate must be is a demand for possession. You say you have to be out. You have violated your lease, or you have never had the right to be here, or you no longer have the right to be here because of X, and therefore you must leave within these number of days, or I will evict you. And so your notice to vacate, an unequivocal demand for possession, it's not that different depending on the facts. But if every time your notice to vacate is you must leave within X number of days, that applies to every kind of eviction. So there's nothing special for a squatter. And just to be clear, and I'm going to do a video on this pretty soon because some of the laws changed in the state of Texas. There are actually much fewer squatter cases than most people think. The definition of squatter is usually misunderstood, and a lot of people who you think are squatting really are just holding over, or they are unauthorized occupants. It's not the same thing. So, okay. Vishal Bansal, is there any way to recover the missed rent payments and property damages from a tenant that was evicted? I've done a number of talks on this particular topic. Yes, there's a way to do it, but it's complicated because, and you got to ask yourself two questions. The first, once they're gone, can you find them? If you can't locate the tenants after they've left, then you can't sue them to recover any additional damage. But let's say that you can locate them. The second and probably more important question is there a reasonable expectation you're going to recover any of your losses from them? Because if there's not, I just don't know the point in seeking damages from them when they got no money. And so, yeah, you can get a nice big fat judgment, but if you can't recover it, it's not really going to help you. And so I don't know that I would, strongly encourage you to seek that out when there's just no reasonable expectation you're ever going to get it. So yes, it's possible, but no, it's not super likely that it's going to be helpful. So sorry for the bad news. Let's keep going. Question number 3. This is from Vandell Gentry. I wanted to reach out with a question that has been on my mind regarding the balance between what we as landlords are legally allowed to do versus what is actually the best decision at a given time. For example, I recently had a situation where I followed the eviction process as outlined by you with a tenant who had fallen behind. The tenant had gotten sick, was out of work, needed about 45 days to get back on her feet. At the time, she was almost ready 2 months behind. She was almost already 2 months behind. And although she asked if she could make partial payments, I declined since my policy does not allow that. I proceeded with eviction, remodeled the unit, and got back to the market. But now, 3 months later, I still do not have a tenant. Legally, I was well within my right to evict. But was it the best choice? If I had allowed her to pay partial rent for a limited period, I might have avoided this longer vacancy and actually come out better financially. It reminds me of the saying, don't quit a job unless you have another one lined up. In this case, perhaps, don't evict unless you have strong prospects for a replacement tenant. This has happened a few times in different forms. One tenant was sick, another lost her Section 8 voucher, another lost their job. Each time I leaned on our policy and legal right to evict, but I'm realizing that sometimes some money is better than no money. Well, I would definitely have to dig into these facts. One thing that I would say is, one of the things we certainly don't recommend is waiting 2 months before you act on the eviction. That's one way you're going to lose a lot more money. But if you're saying, well, it's better that I had a terrible tenant than if I have a vacant house and I have no way of making money. Maybe. I just don't know the real reason why it's taking so long to find a new tenant. It's possible that there have been changes in the market and that now the amount of rent that you're seeking isn't justified. It's possible that the market is oversaturated with rental properties. That's another factor that could be there. It's possible that there's not enough good advertising going out to capture a good tenant to put in place. I honestly don't know what's going on and what's affecting this situation, but I would say that, and this is something that we go around and talk about a lot, that having an empty unit is always better than having a bad tenant, because bad tenants are simply going to drain your energy and cause stress. And so if you've got an empty unit, maybe there's work that needs to be done to improve the quality of the unit. Again, another factor that's within your control. But all of these factors are, to some degree, within your control, right? You can lower the rent price, you can advertise more, you can have an open house, you can put a fresh paint job on the property, all of which makes the unit more attractive. But if it's in the hands of somebody who isn't paying you rent, you can't do any of those things. And here's the thing. If you'd have that same terrible tenant in place, let's say for 6 months, and they left, and you have all these same market conditions, guess what? You're going to have the same result. It's not going to improve the market just because you left a bad tenant in place. And so I don't necessarily subscribe by the theory that you shouldn't evict unless you've got somebody waiting in the wings. My philosophy is always, you're better off getting rid of a bad tenant and working on those things that you can control. And so by improving the property, getting a better idea of the market, hopefully you can get a good tenant in place that you keep. And again, I wouldn't just focus on the short term. When you're investing in this business, you're looking for a long-term tenancy, 3 to 5 years, hopefully. And so you want to hold out for a long-term benefit, even if it means a short-term loss. But if you can control that situation as best you can, you're likely to set yourself up for success, as opposed to leaving your most valuable assets in the hands of someone who's wasting that asset. So that's my 2 cents on it and what has been my experience in the past. Yes, that was your question, Vandale Gentry. I hope that helps. Don Gordon asks, I understand the seller financing and landlording is different. However, does the same steps with late payments leading up to evictions apply the same? Don, I'm glad you asked this question. The real answer is no. There's a difference between a lease and a conveyance or a sale. If your document says, I'm transferring this property as seller to buyer, the fact that you haven't delivered a deed doesn't mean you are still landlord and tenant. At a certain point, and in fact, if the document refers to seller and buyer, you can't evict on that basis until you nullify that agreement. And depending on the way you set up that agreement, it's going to we use that to figure out just how quickly you can actually evict. Because if you did an owner financing deal and you transfer the title over to that individual, you're going to have to foreclose and go through the foreclosure process before you can ever move forward with an eviction. And so, that's going to increase the time tremendously. And so, no, they're not the same. If you have what's called a contract for deed and you never transfer the title over, again, they still probably have an ownership interest that's going to prevent you from evicting them, but the process is a little more streamlined depending on where they are in the purchase process. So it's a complicated thing to ask, but I can tell you in a single word, no, they are not the same process, generally speaking. If you have some sort of conveyance, it's going to make the process longer because you have at least 2 steps. The first is nullifying the original agreement, and the second would be the eviction process. James writes, if a tenant injures another tenant, could the landlord be held liable? Maybe. Probably not, but maybe. I'd also rather have an empty unit than a bad tenant. So let's tackle that question. The reason that, oops, I still got some question here for Van Dale. I'll get to that in a second. But the reason that you might have liability is if you are in some way the cause of the injury. Did you contribute in some way, or is the tenant fully to blame? Again, this is a very fact-specific question. Generally speaking, there's no liability on the landlord. And in a good lease, you've got some waiver of liability where they assume all liability for the things that they do. And you really only get stuck with stuff that you did that was a direct result of injury to somebody else. We get into a bunch of scenarios or examples, but I hope that's clear. The question from Van Dale was, how much leeway should a landlord give? While the law allows me to act one way, it's always expedient or wise. Is it always expedient or wise to do so? I feel it's a fine line between protecting the business and showing flexibility. I would really value your perspective on this. Do you think it's better to hold firmly to policy in all cases, or should expectations sometimes be considered when the circumstances are temporary but genuine? And I apologize I didn't get to this part of your question earlier. You genuinely want to consider all factors, but what you don't want to do is recognize that you waited too long before you acted to evict. And if you're waiting 2 or 3 or 4 months, or you've got 2 or 3 or 4 months unpaid and you're on month 6 because you're taking partial payments, that's a huge loss. I would rather that you get rid of a bad tenant first and spend that same amount of time either improving the property or looking for a better tenant. So yeah, take some of these things with a grain of salt, but really only to the extent that your tenant is able to recover. If it is clear they are not going to recover, and that becomes clear in the 30 to 45 days that the eviction process takes place. Right, if you send a notice to vacate and within 30 days they're able to pay everything that's owed, well, you just dismiss your eviction. But what you can't do is wait 3 or 4 months and then begin the eviction process and hope to make up all of the losses in the preceding 5 or 6 months. It just doesn't work that way. You're unable to do it. So I would rather you get ahead of it, even if ultimately you have to evict, and ultimately the unit stays vacant for a bit. Again, you have full control of improving the property in a way that ultimately results in recovery. Let's see, Random Sandwich 2 writes, how long can an eviction process take? The tenant has already had a court date and the judge ruled to continue. The tenant had a check bounce 2 days later. The next court date is in 2 months. Well, that's going to depend entirely on your jurisdiction and where you are. If you are in Texas and this happens, it's also going to depend, are you in the justice court or are you in the county court? Now, the law in Texas is strictly written to say you've got to be done with your eviction in 21 days, but it's not followed very well. There have been some changes in the law that hopefully will improve that. But 2 months, that's a long time. You do have other options, though. And so in the justice court, you have what's called a motion for summary disposition, which can be heard in as few as 14 days. In the county court, you have a motion for summary judgment, which can be heard in 21 days. So if ever you've got a setting that's way out, and this sometimes happens when the tenant requests a jury trial. It's a tactic that they know sometimes extends these trial settings. And so a motion for summary disposition or a motion for summary judgment might be exactly what you need to speed up the process. If you're unfamiliar how to get this done, I would consult an attorney in your jurisdiction. Don writes, so how would owner eviction and owner occupant if they're not paying or in default and the agreement is not the same as a tenant-landlord relationship? To really answer that question, Don, I would have to see what the document does say. Does it allow for rescission? Does it allow for some kind of unilateral termination? Or does it require a foreclosure? In some way, you have to terminate the ownership rights before you can move on to eviction. When you have an owner financing issue, that's usually the first hurdle. can you terminate the ownership right of the individual who was originally purchasing the property? V Gentry 83, I agree this is better to have a vacant unit than to have a bad tenant. Random Sandwich 2, thank you. You are very welcome. Let's move on. Jessica Van Cloyd, in Texas, what can be charged for cancellation prior to move-in after a lease signing? I see lots of competitors essentially forfeiting the security deposit, which I don't think we can do. How is this being ruled on in the courts? Well, this is going to depend on a couple of factors. First, does the landlord have any culpability for the tenant being unable to move in? If that's the case, you have zero claim to any rent or that deposit. You are in breach and you got to return that stuff. But let's say somebody has paid rent and a deposit, and it turns out, oh, something weird happened. I got to go to another state, so I won't be able to occupy. Just send me my money back. Well, the law allows one of two options here. The first is if the tenant finds a replacement before the beginning of the lease and you accept them, then they have no losses. You have to return all the money. Now, they would also have to go through your entire vetting process for this to make any kind of sense. And so I don't know if that's necessarily going to happen or not. But if it does, then great, you have no losses and they have no losses. But the other situation is, what if they don't find a tenant, or the tenant they find is terrible and you don't accept them? Well, then you have the rest of the lease to consider. They owe you the entire lease, but you as a landlord have a duty to mitigate your damages. So even though the tenant wasn't able to find a replacement, the moment you know that original tenant is not coming in, you have a duty to go and find a replacement. And let's say it takes you 45 days after the start date of that lease to find a replacement, or you're owed 45 days worth of rent. Let's say that means the entire first month of rent that was paid, you get to keep, but only half of the deposit. Assuming you have no other costs, you owe them half of the deposit back. And so that's the way you would calculate those damages. Let's say instead it took the same 45 days. That's 45 days worth of rent, so you have half a deposit, but you had to pay another reletting fee to your realtor to find another tenant. And the fee that you paid was 1 month's rent. Well, guess what? That half month that would have otherwise gone is now forfeited or applied to your realtor, and now you're out half a month of money because you had to pay that on top of the you had to pay that directly to your realtor, and that's money that you lost. And so in that situation, you suffer damage, and of course there's no deposit. But let's say in this situation, it just so happened that 7 days after the first month began, you found a replacement tenant all by yourself. You didn't have to pay any reletting fees. It was so fortunate. Somebody came in, they were able to pay the rent and security deposit, so that your only damage was actually 7 days of unpaid rent. You owe the balance to the tenant. You can subtract those 7 days, and if there are no other costs, the rest of the prepaid rent and the rest of the deposit go back to the tenant. So make sure you're able to calculate these things and make sure that you're able to justify anytime you keep everything that a tenant pays you on the basis of some forfeiture. You want to be able to prove to any court that you had a just right to keep all the prepaid rent and all of the deposit that was paid based on your facts. Okay. Next question. Abigail Munoz writes, I have a landlord policy which restricts certain dog breeds on the property. How does this work with ESA guidelines to the tenant? Well, make sure that you are aware that that policy is still in place. Find out what happens if your tenant violates that policy, and make sure you have that information in writing. If it turns out that your insurance will terminate your insurance policy if the presence of any of these kinds of animals are there, and it turns out that your tenant has one of these animals which violates the ESA policy, then very much like the question from earlier about reasonable accommodations, you can tell that particular tenant, look, it is unreasonable for you to ask me to allow this animal to come onto the property based on this policy. Make sure you're able to demonstrate it and make sure you have it in writing from your insurance company that these things are excluded or that these things would otherwise nullify your insurance policy and that no claims would be honored if this animal were on the property. So the fact that they just tell you anecdotally is not enough. You want to see it in writing. But yes, you potentially could, if you are in an extreme position where you will suffer harm by accommodating them, then you have an argument against whether or not that accommodation is reasonable. Okay. Don Gordon follows up. If I own properties and I'm the seller, financing them out to people who would be the best attorney to consult with my particular situation, would a traditional landlord attorney suffice? I mean, I guess that would depend on that landlord attorney's experience. I don't know if you're in Texas, but we handle these kinds of cases all the time. And so if you're interested in talking to us, I'll be happy to review your case with you and let you know what we would do based on what is in the written agreement or how we would suggest bringing that document or those rights in the document to an end so that you could remove the people from the property. So hard to say. I'm not exactly sure where you are. If you're in some other state, Don, unfortunately, I can't guarantee that that ultimately just any landlord attorney would suffice. But I can tell you for Texas, we handle those kinds of cases all the time. So here we go. Jessica Van Cloyd, this is the last question that we've got. If you've got a final question to ask, feel free to add it into the chat before we close things out. We are getting close to the hour. And here is Jessica's question. What about payment plans? Does a tenant need to be reserved a 3-day notice if a payment plan is set up post-delivery and they then default on said payment plan, provided there is a clause about this in the payment agreement? Well, maybe. It depends what the payment plan was and what it said. But I can tell you that in a number of cases that we file, we enter into agreements just like this. Now, what we tend to do is we wait until the eviction is filed, and then we file what's called a Rule 11 agreement, which we file with the court as well, which says, tenant agrees to do X and Y and Z. And if the tenant fails to do that, we're holding a separate document, which is an agreed judgment, which we can file immediately upon the default at any point. And so what we usually do is we continue the matter for some time to allow the tenant to comply with each of these terms, X and Y and Z. And upon completion, many times we non-suit the eviction. We dismiss it. It goes completely away. But if any one of these things does not get completed and they fail to do what they promised, we simply take the agreed judgment, file it with the court, seek the eviction, and then proceed to have them removed. So if you're going to have some kind of agreement, it should have some teeth to it. And if you can't enforce it otherwise without an eviction, I would recommend filing that eviction anyway and making sure that you've got some mechanism to enforce a future default. Remember, they're already in default. You're already in a position where you're having to, ask the courts to force them out because they can't follow their agreements. If you're going to give them a second agreement, make sure it's got teeth that you can use to enforce in the event that they breach again. Chuck writes, can you talk about some of the upcoming changes to the property code? Yes. In fact, I've got a video coming up. In fact, I've got the printed code on my desk right now. I'm presently working on a video, which I will get out Labor Day weekend. Some of the code for the Texas law anyway goes into effect September 1st. I'm going to have my video go out that same day. Other parts of the code, very interesting parts, won't take effect until January. But yes, Chuck, I will have that out for you later. I'm shooting the video within the next week or so, and I will have it out September 1st, which is Labor Day. So, Don writes, I'm in Florida, but my properties are in Virginia. I'm asking because my bottom line is, how would I be able to get them out of the property if they're in default but have ownership interest? Yeah, that's tough. I'm not familiar enough with Virginia law to be able to, to really be able to help you out. And so kind of can't help you with Virginia law. But I would recommend hiring a real estate attorney with landlord tenant experience and with conveyance experience. And basically, if you hire a real estate attorney with landlord tenant experience, they should be able to help you. But again, I can't speak for how things run in the state of Virginia. Chuck says, perfect, thank you. You are very welcome. James, thank you, Ernie. Have a great weekend. Do the same. I look forward to, being here again next Wednesday. We will do the whole thing all over. I'm really looking forward to that. I hope you have benefited from all of this. And until next time, landlords, I hope you have a great rest of your week and happy leasing.